Okay, I think we're good. Hi, everyone. Welcome to Legislative Lens, our live monthly Zoom series brought to you by the California Lawyers Association Family Law Executive Committee, or what we call FLEXCOM. Each month, we break down what's happening at the Capitol, proposed bills, policy updates, position letters, and legislative developments shaping family law across California. We also feature special guests from the legal community, sharing practical insights, practice trends, and what's impacting families statewide. So a couple of housekeeping things before we jump in. If you're here live, welcome. We're happy you're here. If you're watching the replay later, hi, still counts. Love that for you. But just remember that the self-study credit is only applicable to the people that take the live course. If you're watching us on the replay, you don't get that. So sorry. Join us on the next one. The series, of course, is live on the second Thursday of every month at noon. And today is extra special because this is our first ever episode. So thank you for joining us. I am Leslie Abrigo, Certified Family Law Specialist and Chair of the for 2025-2026 California Lawyers Association Family Law Executive Committee. I am your host today. And I want to say right up front, this show is designed to be clear, accessible, and actually useful for family law attorneys who are in it every day. First, I'll run down the format. We're going to do a quick featured guest segment, about 10 to 15 minutes, where we spotlight a leader or practitioner during doing meaningful work in our statewide community. So this will be like every episode. And then we're going to do the legislative update portion, where we cover key developments, proposed legislation, and policy shifts impacting California family law. And today, specifically, we are reviewing new laws and amendments effective January 1, 2026, including amendments to Family Code Section 2040 that FLEXCOM sponsored. All right, let's get into our guest segment. Today, we're joined by Greg Gillette, who's deeply connected to Minors Counsel practice and training and tied to the San Luis Obispo County Bar Association Minors Counsel training. FLEXCOM is co-hosting the Minors Counsel training in San Luis Obispo, so this is a perfect fit for legislative lens, statewide impact, real practice, relevance, and training that supports better outcomes for kids. Greg, thank you for being here.
Well, thank you for having me. I appreciate it very much.
So for people who are meeting you for the first time, what's your practice look like and how would you describe the work you do?
So we have a pretty general practice. We are litigators here. We do everything from trust and estates, contract disputes. If we're appointed, we do criminal matters, and we have a robust family law team. So we do a lot of family law. I personally, most of the family law I do is within minors counsel training, minors counsel work.
So how long have you been doing Minors Counsel work?
Over a decade at least, as far as I can go back to doing family law. So 12 years or so.
And what drew you to that area?
Well, we all go to law school for different reasons, and some of them are pretty specific. Um, and I went to law school because I wanted to help people, and this was a way that I saw, in the family law practice when I was in work. I saw the court appointed minors counsel and the work that she did, and so that drew me to it. It's sort of a mitzvah that we can do to assist the court and assist the most vulnerable participants in our process.
And Minors Counsel is one of those roles that people think they understand until they actually do it. So, in your opinion, how do lawyers and sometimes litigants most often misunderstand the role of Minors Counsel?
So it depends on the county, and I've operated in several counties, but I think the biggest misunderstanding is that the attorney for the child has the power to make orders, right? It has if you have two, even with attorneys on both sides, both attorneys believe that you have the ability to change the court orders because something isn't right with the child. Um, the other big misconception is that minors counsel make recommendations to the court. There's a recent appellate case that basically says the term recommendation is essentially an argument in favor of their client. Really, what we're supposed to do as attorneys for minors is to be their lawyers. and act exactly like lawyers for the parties. And so anything beyond that is a misconception.
What are the most common ethical traps you see newer minors of counsel attorneys fall into?
I think the biggest one, there's two. The biggest one is who do we represent? It's easy to turn yourself into a mediator when you represent children because you're trying to broker a deal that it may or may not be in the best interest of the child, but you want to put the parents in a position to parent the child instead of the court. And in that role, you still have to remember you're an advocate. The other, probably most difficult one that I've seen most often is when you represent more than one child. Often a judge will appoint you for all the children in the family. And if there are two kids, especially if they're teenagers, they may have divergent uh, um, views. Their preference may be different. They may, be part of the issue that's caused the parents to be at conflict. So you then have to decide which one, if any, you're going to represent and advise the court that there may be a conflict within representing both of those parties. So those are two big ones. And then of course there's the concept of bias between one parent or the other. I think that's a very interesting subject we could talk all day about. Um, but th those are the big three.
And okay, so if you had to pick your top three non-negotiables for minors counsel training, what would they be?
In what sense? More.
Like what part of the training is the most important to you, especially considering the fact that you've organized or you're one of the organizers of this training in San Luis Obispo?
Yeah, I think so. I think fundamentals are really important. Be understanding what the law says. 3150 is our guidance. But within our training, we are very practical in how it works. So that's a non-negotiable. If we do a Friday and Saturday session, the Friday session are for newer or new minors counsel, and I think it's just really important to know what the heck we're doing. The other is the training for special populations, children with special needs, cultural competency, things of that sort, because that is where the most misunderstanding happens. Is when you have a child with very specific circumstances, it's very easy to oversimplify and actually do more harm than good. And then we do a lot of training on really how to talk to kids. I mean, law school sucks the life out of you or the soul out of you, and you forget how to talk to real people, let alone kids. And I think it's important for us to constantly be training on that and remind ourselves that they have a very different view of who you are than what you think they might have. I mean, that you're an attorney. Most of them, if they're under the age of 15, they don't know what an attorney is. They just want to know if you've held a snake and jumped out of a plane. And that's how you connect and really get close enough to the child so that you can get the information to, serve their best interest.
So, since we're already talking about the training, what is your connection to the San Luis Obispo Bar Association and this program?
So I'm a former president of the Bar Association, and about 7 or 8 years ago, I took over the organization of this training. So my role is really to put together the speakers. We've been doing this will be our 10th year. We're super excited about specifically this one. It's in the beach or Pismo Beach at the Cliffs Hotel, and you can also do it online, by the way. But my role really is to put together the best program um, that I can. And having done it for so many years, I get a lot of help with that. I mean, this year we have a lot of input from judges, for example, um, judges who want to sort of calibrate what they're doing in their courtroom with other courtrooms. Because again, as with many things, you can go from one county to another and things are completely different. And because minors counsel is so nuanced, um, our minors counsel work is so nuanced. You see variations from one courtroom to the next. So This year's put together a really good program, and I'm really happy with it.
So for people thinking about registering, give us a snapshot. What is the program and what's the overall goal?
Okay, snapshot. Friday, we do only online, and that again is the fundamentals. The reason we do that mostly is because we start at noon and we go till about 4:30. We wanted to do it online because we know how Friday travel is. We want people to either come here early and there's a room where people can join online, or they can take it from where they are and travel afterwards, depending how far they're coming. But that first day, it's fundamentals, how to submit evidence, how to read fundamental documents, what to do, how to get paid. That's an important situation, especially if it's county pay versus private pay. And then Saturday is when we do all the other things that don't necessarily follow with normal MCLE. This year, for example, we'll be exploring how marijuana use by parents can impact children, or not. We are going to have a cultural competency presentation by an expert in multiracial children and impacts on their psyche. And all of these things put together are to make us more well-rounded the approach representing children. Because remember, we don't have an actual party to the action. We represent children who can't and shouldn't necessarily on the stand. So we have to get as much information from them in different ways. So Saturday, 8 in the morning, we start, we go through the day, one right after another, and it actually sounds exhausting, and it is, but it's just so much fun having everybody together. They're actually enjoy the energy that we have, the ideas that we've come up with in the past, 7 or 8 years of us just being together and being colleagues and collaborating. The people that have attended in the past are just brilliant. They're brilliant lawyers. Their heart is also in the right place. And so the ideas that we get from just being together is probably the best part. But the coursework is pretty phenomenal as well.
So when I went to the registration page, which is in the chat, I noticed that there were two different options. Can you like explain what those options are and who should be looking at which type of option?
Sure, if you've never done minors counsel training before, you're required under the rules of court to do 12 hours of training. And so you'd want to sign up for that one. And again, for people who have never done it before or haven't really maintained their annual training, that means you'll go to the Friday and Saturday courses. If you have done it before and you're just renewing your training, or you believe you have fundamental training already, you can take the 8-hour course, which is held on Saturday. So depending on what you need, if you're new, take the whole thing. If you like to just renew and update yourself, then take the 8-hour training.
So the details, it's March 13th to 14th, 2026 at, as you said, at the Cliffs Hotel in Pismo.
That's right.
What, two quick questions
Sure.
to wrap this up. What's one piece of advice you'd give a first time minors counsel after their very first appointment? Sorry for the sirens.
Well, the best piece of advice is really rely on the code. Understand what it is your job is. It's almost with every lawyer. Who's your client? What is it? What goal do you have? And be flexible when doing that. But follow the law to a T. That just makes everything easy. Do the easy stuff well, and it gives you time to grapple with the hard stuff.
Okay, thanks. And then one last question. If so, this program can be taken by anyone, even people that are not wanting to become minors counsel. And so if someone is on the fence, give them your 30-second why it's worth it.
Well, again, it's what you want to do. Listen, there's a lot of people who have taken this that want to know how in this, game minors counsel, right? They're representing mom and dad all the time, and minors counsel is getting in the way, or they don't fully understand the position. Take the classes, just see how we're being trained. I don't mind that. I think more information is better. But if you have, listen, it is more helpful. It's not. And really for me, and again, I didn't train in family law in law school. Um, I'm a litigator. I My focus isn't necessarily on being a family law attorney, but really when it comes down to it, these kids in these high conflict cases need somebody to advocate for them because they're almost always lost in the discussion. I mean, both parents really honestly believe that they're hurting the best interest of the children, but there's something usually missing. The higher the conflict, the more that they get. But for me, being able to offer that service, and it's really the most joy I have in my practice. When I'm finishing up a case today, in fact, and this young lady's going to be 13 tomorrow, and I started with her, and to watch her grow and know that I've been able to at least be a part of her story in in putting her in her place, be happy and thrive. That's worth it. That's kind of how I measure the success of my practice is, how much am I proud of and how many people I can help. And so that's my pitch. It's not for the money, but I will tell you, I've become a more skilled lawyer by representing children because the stakes are a lot higher, and I just do better. And I think that it's such a good opportunity for people who want to take one or two cases and assist the court and really do well for kids. So I appreciate you and FlexCom for giving me the time to talk about this. The website is minorscounseltraining.com. You can just go directly there and purchase tickets. And if you have any questions, feel free to reach out to me.
Awesome. Thank you for that. Very noble to be a minors counsel, as everyone knows who practices family law. So, Greg, thank you for being here. We really appreciate it. So, good luck in the rest of your trial.
Thank you. Thanks, everyone. Leslie, Shannon, Brooke. Have a good day, everyone.
Bye. Okay, so we are now going to move on to the part of the show where we talk about what FlexCom does, and that is discuss legislation. And for that, I get to bring on my co-host. In the words of the talk show host, Wendy Williams, she is an icon, she is a legend, and she is the moment. Shanon Quinley, how you doing?
Hi, everybody. Thanks for being here. I don't know who Leslie was describing, but I'm here to talk about legislation. And I appreciate you all taking your lunch break out to meet with us. So I just wanted to share, I'm going to share my screen. I do have a PowerPoint presentation here that will be shared with you. You'll be getting this in an email, if not today, tomorrow. And you'll be able to use the PowerPoint not only to refer to, but there are several links towards the end that will be live in a PDF that you can use to find out more information about things that you might be interested in. So as Leslie indicated, my name is Shanon Quinley. I am actually the legislation chair for CLA FlexCom. So part of my role in being the legislation chair is that I track legislation throughout the legislative session to make sure that we are following up on and making sure that we are educated about any kind of pending legislation that may affect the practice of family law. So last year and up until January 1, 2026, there were several different updates that we wanted to let you know about. And so that was sort of what we are going to be focusing on today. So here is our agenda for today. We have several different bills that are going into effect January 1, 2026, or bills that have already gone into effect that are now affecting something that is new for this year. So we're going to talk about support and financial issues in two bills, some procedural issues that you need to know about. Always lots to talk about when we're focusing on domestic abuse, and one interesting child custody bill, and one bill that is relevant to those of you who serve as minors counsel or will serve after taking the training in Pismo Beach, if that's something that you decide to do. All right, so starting out with support and financial issues, and the first bill that I wanted to talk about was AB 1297, which is about automatic temporary restraining orders. And we're starting with this one first because this is a bill that we're very proud of, because this was actually sponsored by California Lawyers Association FLEXCOM. And we were able to put this together. We found a person in the legislature that was willing to carry this bill for us, and we actually were able to get it passed in the last year. So this is what the bill does. So we all know about the automatic temporary restraining orders in Family Code Section 2040. These are the things that are printed on the summons that we explain to our clients, that will indicate what you can and can't do until the resolution of their dissolution case or legal separation. So primarily focusing on just the financial restraining orders, we know that there's a provision that prohibits the parties from cashing, borrowing against, canceling, transferring, disposing of, or changing the beneficiaries of insurance or other coverage, including life, health, automobile, and disability, held for the benefit of the parties and or their children for whom support may be ordered. So the issue that we were discussing in trying to figure out what we could do to solve this problem was that a lot of times there comes a point in the litigation where there's an insurance policy that is about to expire, or there is a payment that is coming up and is going to be due for a policy, and one person just decides not to renew the policy or just stops paying for the policy and lets it lapse. And so if you are not the party that's in control of the finances and you are dependent on the other side for management and control, or you're just not familiar with how to get these things paid, at least initially in the early stages of the divorce case, you may find yourself without coverage. And so we thought that that was a gap that needed to be filled. And so we wanted this to be a solution to the problem. So this bill adds the language allowing to lapse for non-payment of premiums and failing to renew to the list of restraints related to insurance coverage. So this would require both parties to continue to pay for the premiums on a policy and continuing to renew a policy, thereby preserving the status quo until the case is resolved or until there's a court order or the parties agree on something otherwise. Now, this is a new bill that was passed, but it's not going to be effective until January 1, 2027. The reason for that is that the Judicial Council needs some more time to be able to create revised forms. So this is going to require that the Judicial Council revise the summons, and that will be available next year. So although this isn't in effect at this point in time, it's probably a good practice to start advising our clients that this is going to be the law and start operating under the assumption that they need to continue to pay the premiums and they need to renew policies to preserve the status quo. All right, the next financial issue that you should be aware of is the bill SB 711, and this has to do with taxation and bringing the state laws into conformity with the federal laws. So every so often there is an omnibus bill that's passed that is designed to bring the state law with regard to taxation into conformity with any recent changes in the federal tax law. And this has not been done in California for quite some time. So there are 10 years worth of revisions to the federal tax law that has not made its way into state tax law. And so for our purposes, one thing that was difficult to reconcile was the fact that in the federal world, if you are the payor of spousal support, at one time that was deductible and no longer is deductible based on a change in the tax law. And California had not made that change. So you had inconsistencies with how the treatment of spousal support payments would be taxed or not taxed. So now everything is going to be aligned, and it's all going to be treated the same, whether it's federal or state taxation. So consistently now, spousal support is no longer deductible to the payor, and the recipient is not required to include it as income if it's paid pursuant to an order that was executed on or after January 1, 2026. Now, one point that we need to keep in mind too is that if you're dealing with modifications of orders executed on or before December 31st, 2025, the new law will apply if the modification says that the amendments will apply to the modified order. So if you want the new order to reflect the current tax treatment, you're going to have to state that in the language when you are making a modification, either through a stipulation, or if you're asking the court to make a modification of an existing either temporary order or a judgment. You're going to want to make sure that you're asking for that language, that the new law applies to the modification if that's the intent of the parties or that's the request that's being made. Okay, next up is the issue of procedure. And here's one that is something that was in the prior legislative session, the prior 2-year legislative session, so 23-24, but is relevant for today because of the fact that it is now effective. So this has to do with being able to file a joint petition for dissolution of marriage cases and also for legal separation cases. So as you may already know, existing law allows for individuals to file joint petitions for summary dissolution, but a lot of our clients are not going to qualify for the restrictions that are present in the law with regard to summary dissolution. So you're not eligible to file a summary dissolution if you have children, if you have a long-term marriage, if you have a house that needs to be sold, and if somebody's requesting spousal support. So most of our clients are just not going to be filing joint petitions for summary dissolution. However, this bill came into play because of the attorneys who usually are focusing their practices on collaborative law or mediation, consensual dispute resolution, and these attorneys felt that there was a need for a joint petition that could be used for the purposes of these cases that are in collaborative or they are being done cooperatively or through a consensual dispute process. And the reason for this is they felt that it would alleviate some of the conflict or some of the elevation of emotions when it comes to filing a petition and a response and having to have that served on the other person. The petition has to be served personally, and the feelings that are sort of inflamed with being served. And they felt that it was a more cooperative process that would be better for the clients if they could just do it in one document without the requirement that it be served on the other party. So that's the purpose of this. And this process has now been established effective January 1, 2026. And this has amended a few of the rules of court that I've listed here, and also has created new forms. So this is the FL 700 joint petition, FL 710, which is a summons on the joint petition. And there's also another form called the notice of revocation of the joint petition. So let me explain this. When the parties are filing a joint petition, they're both going to put their names on the petition as petitioners, but there's going to be a petitioner 1 and a petitioner 2. The summons is going to be issued by the court, but it doesn't need to be served on the other side. Neither of them have to serve this document on the other. However, if the case falls out of collaborative or falls out of the mediation process, and one side decides that they want to now appeal to the court for a litigation process instead of a consensual dispute resolution process, they're going to have to revoke the joint petition. So we have a judicial council form that will allow them to revoke a joint petition. But in addition to revoking the joint petition, they now need to file either a petition or a response. So if they were listed as petitioner number 1 in the joint petition, they file a regular petition. If they were listed as petitioner 2 on the joint petition, they need to file a response. They do need to serve that document on the other side, but there is not going to be an additional summons that's issued. The original summons and the atros that are going to be included in the original joint summons will still be the operative summons in the case.
I wanted to add something here, Shannon, before you move on.
Yeah, go ahead.
There is another form that you submit with regard to entry of judgment. This process has its own notice of entry of judgment paperwork, because the assumption is that when you're filing your paperwork, you're adding the judgment quickly thereafter. And so there will be like a summary kind of a judgment sheet. Although, just to point out, when you look at the codes or the rules of court, you're still going to have to comply with all the disclosure requirements. And the forms are not built with petitioner 1, petitioner 2. Those have not been changed. So when you get to that place in time, I'm sure the Judicial Council will address this at some point in the future. But when you do like your schedule of assets and debts and you're trying to like identify, respondent petitioner, now you have petitioner, you're going to have to identify petitioner 1, petitioner 2, and comply with all of the standard rules that you do for like summary judgment or judgments and disclosures. So that's all I wanted to point out.
Yeah, thank you. And there was a question in the Q&A. The question is, Lori Ramirez is asking, if the parties decide to revoke the joint petition, do they have to pay another filing fee? I think the answer to that question is no, because when you're filing either if it's a petition or a response after you're revoking, you are filing either an amended petition or an amended response. So you've already made your first appearance fee when you file that joint petition, because both of them have to pay a filing fee. So when you revoke, it's not an additional appearance. So they should not have to pay another filing fee for that. Okay, so that is the new joint petition for dissolution. And again, this applies to not just dissolution of marriage cases, but also legal separation cases is an option here if they want to do a joint petition for that. Okay, the next one is AB 515, which is changing the way that we are going to request statements of decision at trial. Okay, so this one is not going to be in effect until January 1, 2027. Usually when you see these dates that are in the future for the effective dates, it requires something to be done, usually in terms of a form. And so that's what is happening here. And also there are existing rules of court that are going to need to be amended, or one primary rule here. So the existing law here that was sort of cumbersome was that there were deadlines for requesting a statement of decision that were based on the length of the trial that were confusing. So there was language that says prior to submission, if 1 day or less than 8 hours, or within 10 days after the court announces its tentative decision, if longer. There was language in the rule of court that was a little bit different than the CCP section that dealt with the same issue. And so this bill is designed to clarify the language and align everything and simplify it, so not just attorneys, but also bench officers are all clear about the statement of decision process. So this bill changed the law. So now it simplified the procedure, and it says that in all bench trials, the request must be made in writing or orally if there is an official record of the proceeding being transcribed. So if you have a court reporter there, you can do it orally, but it's got to be done prior to the submission of the matter for decision. And it also allows the court to order a party or parties to prepare a draft statement of decision. I mean, that could have been done previously, but this clarifies that the court can order a party to do that. So make sure that you're starting this practice now, even though it goes into effect January 1. Just start getting into the habit of requesting these statements of decision prior to submission on the submission of the matter, because you want to make sure that once this goes into effect, that you are actually doing this and you're making it in writing or on the record before submission of the matter for the decision. And this was actually sponsored by the California Judges Association. I think the judges were sort of sick and tired of having to deal with all of the confusion, and so this bill was designed to simplify everything for everyone. Now, it does require that the Judicial Council adopt or amend the existing rule of court and to prepare a form for a party to request a statement of decision and an information sheet that explains the procedure and applicable deadlines. So all of that should be ready for us to start using January 1 of 2027. So be aware of that. Okay, the next issue that we're going to cover is domestic abuse. There always seems to be several bills that are making its way through the legislature that deal with domestic abuse. Several of them don't make it through, but we always have a few of them that seem to make it through, or they are revived in a later session. So this year was no different, and already I'm looking forward to this year's session, and we already have some domestic violence bills that are being proposed. So this is always a hot topic. Okay, so let's jump into it. So the first one is AB 1363. This deals with protective orders. This one is called Weiland's Law. And this is a bill that was introduced because of a tragedy that happened in the court system with regard to a domestic violence case and a child being killed by the restrained parent. So the existing law here is that superior courts are required to transmit protective orders to the Department of Justice. And the reason why it goes to the Department of Justice is that this needs to be the information needs to make its way through, so that if the restrained party applies for a permit to get a gun, that the background check will indicate that there is a restraining order and that this person is not eligible to receive a gun or to purchase a gun. So this is a problem because in 2016, in this particular case, there was a failure of the court to transmit the protective order to the Department of Justice, and a restrained parent was able to purchase a gun and ended up using that gun to kill the child who was 10 years old, and his name was Weiland, and that's why we have this law. And this law is referred to as Weiland's Law. So the problem is, why was this not in the system? Why did the DOJ not have a record of this? Why was this allowed to happen? And this mother in this case wanted to find out, how did the system fail her and how did this go wrong? And so she tried to get information about what occurred and whether the DOJ had received the information about the restraining orders and whether the Superior Court had transmitted it properly to the DOJ. And she had a terrible time getting this information, and she had to file what the California version of what's called a public records request. And when she did that, they were not happy to give her the records, and she ended up having to file a lawsuit to get the records that she requested through the Public Records Act. And once she did, and once she was able to find those records, she was dismayed to find that 3 of the 4 DVROs that were issued against Weiland's father were not transmitted to the DOJ, including the order that was in effect when he purchased the firearm. Okay, so all of this sounds great, that there's a solution to the problem. However, let's talk about what this bill actually does. So this bill adds a section to the Family Code, which is 6380.5, that says, subject to an appropriation by the legislature, It authorizes the establishment of an automated protected person information and notification system to provide a petitioner or a protected person in a DVRO case with automated access to information about their case, including the records relating to transmission of the restraining order to law enforcement, whether the restraining order has been served on the respondent, and if the respondent is in violation of firearm purchase restrictions. So all of that seems to be fantastic, that this stuff would be available to us and our clients if we were able to access this centralized sort of database or this notification system. However, the preface of this is that it requires an appropriation by the legislature to create this system. And so at this point, we don't have an appropriation by the legislature. When this bill was sort of making its way through the system, it was opposed because of the fact that it was going to require an appropriation, and California's budget is not going to necessarily allow that. And it was in danger of not making its way through the process to be passed. And so this language, subject to an appropriation, was added so that this bill would not fail. However, in order for it to actually start to do what it was intended to do, we need the money behind it. So this bill is effective January 1, 2026. However, unless and until the appropriation is passed by the legislature, it may not be active and able for us to be able to use it in our cases. So we'll keep you updated on this if we see a bill that now introduces the appropriation. Just a note here that this was sponsored by Giffords, which is an anti-gun violence nonprofit, and so there was no opposition here to it, except for prior language that did not have the subject to appropriation by the legislature part. So once that was in, then this could be passed. But if there's money and there are no budget dollars for this, then that's when there was some pushback here. But this was passed, and hopefully this will get some teeth in a future legislative session. Okay, the next one is SB 50, which deals with connected devices and device protection requests. So this one is in effect January 1, 2026, and it amends the Family Code Section 6320 to expand the definition of conduct that disturbs the peace of the other party to include conduct committed through the use of an internet connected device. And so what that is referring to are things like, if you think about smart homes, and you've got all this technology that is basically running your house. It controls things like the lights or the thermostat or even your appliances. And there are apps that you can put on your phone that will allow somebody to control all of the devices in a house, including the cameras, maybe even the locks. And so if you have this control and this app on your phone, and the other person now has a restraining order that has excluded you from the house, you can still have control over that protected party that's left in the house with the app on your phone. And so the report and the basis for the need, or the stated need for this bill, was that you were having protected parties that were still not safe in their home because the out spouse, the restricted party or the restrained party, was still causing interference and disturbing their peace by controlling the technology within the house. So this adds that to the definition of disturbs the peace, and it also creates something called a device protection request that allows a protected or party or a survivor of abuse to contact an account manager, and requires the account manager, after receiving a request, to terminate or disable the perpetrator's access to the connected device or the user account. So in doing that, the actual basis for the protection request is in Business and Professions Code Chapter 13.5, which is the addition. And the definition, of course, is 6320 in terms of the disturbs the peace expansion of the definition of what disturbs the peace. Okay, so that's SB 50. Okay, another new issue that we need to know about, AB 2759, which was coming from a previous session, but it's in effect now as of January 1, 2026. And this deals with domestic violence protective orders and possession of a firearm. Okay, so existing law already allowed somebody who is prohibited from under a DVRO from owning, possessing, purchasing, or receiving a firearm or ammunition while the order is in effect, they can, or they could prior, ask for an exception to that if they have a job that requires them to carry a firearm as a necessary requirement of their job. So courts could already grant an exemption from the firearm relinquishment order. If the respondent was able to demonstrate that a particular firearm is necessary as a condition of continued employment and the current employer is unable to reassign the restrained party to another position where a firearm is unnecessary. Okay, so that was the existing law. The change here is that this bill revised the exemption to the firearm restriction and requires a court to find that the restrained person does not pose a threat of harm to the protected party or the public. So if they are going to grant this exemption, there has to be a finding that this person is not a threat. And in addition, if the restrained party is a sworn peace officer, the court must find that the peace officer's personal safety depends on the ability to carry the firearm outside of scheduled work hours, and they do not pose an additional threat of harm to a protected party or the public. The change also requires a mandatory psychological evaluation of the peace officer to be conducted by a mental health professional with domestic violence expertise and requires the court to consider the results of that evaluation. So that's a pretty high burden that is now going to be required. If you're dealing with somebody who is not a sworn peace officer, but they still are going to make an allegation that they need their firearm for their job, they may only possess it during work hours, so they can't use it, they can't take it outside of work, they can't keep it at home and then drive in their car and take it to work and then take it home at night. They can only have access to the firearm during their work hours, and the court may, but is not required, but may require a psychological test before granting an exemption. So this is effective January 1, 2026. And again, it makes it a little bit harder for restrained parties to be able to meet this requirement to qualify for an exemption. And as I'll talk about in a minute, this also is leading to some additional forms, some changes in judicial council forms. Okay. All right, more about this one. It was sponsored by the Women's Foundation of California, Solis Policy Institute, and was supported by numerous firearm violence prevention organizations and anti-domestic violence organizations. There was no opposition. The new mandatory forms that exist, the one new mandatory form is the DB 850, and this is called permission to have firearm or ammunition for work. So if this is going to be an order that the court is making, they have to do it on the mandatory form. And there are a few revised mandatory forms here that will be relevant for this. The CLETS form, the response to the request for a domestic violence restraining order, which will allow the restrained party or the respondent in this case to request that exemption. And DB 130, the restraining order after hearing, has also been revised. There's an optional form now that's available that will explain how a respondent can respond to a request for a domestic violence restraining order. Okay. AB 561 is another restraining order bill. This bill amended Family Code Section 6307 to allow a petitioner to file a request for a DVRO electronically at no charge. And it specifies also that no fee shall be charged for a party, a support person, or a witness to appear remotely at the hearing on a request for a DVRO. So this is not going to go into effect until January 1, 2027, but this simply just dealt with making sure that there is no fee for the filing electronically of a request and then also the appearance electronically. So not too complicated there. Okay, a new issue that is still sort of evolving. So let me talk to you a little bit about the recent legislative changes that have led to some changes that are in effect as of January 1 of this year. So virtual visitation and abuse cases has sort of been working its way through the legislature in different bills, but this concept, which is not essentially new, we've been doing virtual visitation before. I'm thinking about cases where you have like deployed military parties and you're using virtual visitation to allow them to connect with their child while they're deployed. And so we may have seen this in cases before, but virtual visitation in the context of abuse cases has been sort of a hot topic, and the legislature has dealt with a couple different bills and proposed bills that have it. So recent legislative changes with regard to virtual visitation that are relevant to what's happening now. Okay, so let's go over a couple things. So January 1 of 2024, SB 59 went into effect, and this made a number of changes to several family code sections. So they included the following. So when there is a case where there's an allegation of a history of abuse or substance abuse by a parent, the court must state in writing or on the record that the order protects the safety of the parties and the child. So not only does it have to be in the best interest of the child, but now it has to say that it also protects the safety of the parties and the child, in addition to being in the best interest. Also, when a DVRO has been made, the court must consider whether the best interest of the child requires the court to make virtual visitation orders, in addition to considering whether visits should be suspended or denied. Also, virtual visitation is defined as the use of audiovisual electronic communication tools to provide contact between a parent and their children as part of a parenting plan or custody order. Virtual visitation may be supervised or unsupervised based on the court's determination of what is in the best interest of the child. And finally, SB 59 also made the change that if the court finds that a party is living in a domestic violence shelter or other confidential location, the court must consider a number of factors in deciding whether in-person visitation is in the best interest of the children. Okay, so that's what 599 did. Then one more, effective January 1, 2025, AB 3072 amended the Family Code Section 3064 to require the court to consider a parent's illegal access to firearms or ammunition when deciding whether there is immediate harm to a child for purposes of modifying a custody or visitation order on an ex parte basis. So essentially, if there is a parent that's restrained, they now have access to firearms or ammunition. This is something that the court is supposed to consider. Okay, so these recent legislative changes are relevant to what is now happening, or what has happened as of this year. So effective January 1, 2026, there are several new rules, new forms, and all of this was sort of done to address virtual visitation. So you're seeing that there's going to be a new rule of court, 5.252, that is establishing guidelines for developing parenting plans and issuing court orders involving virtual visitation. There's a revised standard to judicial administration 5.20 that is called Uniform Standards of Practice for Providers of Supervised Visitation, and this adds a reference to virtual visitation. Also, I wanted to note here that the phrase supervised visitation could also be used in reference to supervised exchanges. So now you're seeing that there's going to be two different categories, and you can either have an order for supervised visitation or supervised exchange, and you can make it clear it doesn't have to be both. And this in concept is not new, but the language that is in these rules and statutes are now clarifying that they're not the same thing, and you can have one or the other or both. There are some mandatory forms now. So there's a DV 150 form that is called Mandatory Findings for Child Custody and Visitation Order. This form is going to be not only addressing the issue of virtual visitation, but it also is a form that is kind of nice to run down. It makes the judicial officer make the findings, the 3044 findings on there. If the court is finding a rebuttal of the presumption against custody that you're seeing in Family Code Section 3044, there are findings that the court needs to make, and there is room in the form for the judge to be able to clarify what was considered and what the findings are. So I encourage you to look at that form, especially if you do any kind of DV stuff. This is a mandatory form that you should be familiar with, but also there is a new form that is not mandatory, but it's optional, and this is FL 351, also mandatory findings for child custody and visitation. So even if you are not involved in a domestic violence restraining order case, now there is a form that can be used in just your regular old custody case, whether that's in a divorce or parentage, dealing with mandatory findings. So if there's an allegation of abuse against the child, if there's an allegation of substance abuse, or if there's an allegation that one parent is claiming domestic violence at the hands of the other spouse, then this form allows all of that to be analyzed and set forth in a nice checklist kind of style. So it's nice to be familiar with it for our practice, but also it might be good to start using these forms and asking the court to use them as well. There are several that are revised here. Again, this is to refer to virtual visitation. And then there are the optional forms that have been heavily revised to include all of these things, all of these references to virtual visitation, and also all of the domestic violence changes. Okay, we're running out of time here, so I'm going to wrap this up, and we can save the rest for the next legislative lens next month, but you will still be getting the slides, and so you can take a look at these at your own leisure. But I'm going to turn this back over to Leslie for some last minute announcements, and thank you so much for your time and attention, everyone.
Thank you. Just so that everyone who is here knows, the amount of legislation that we had last year was incredible. When Shannon and I were going through the legislation that we're going to talk about today, this is just like 1/4 of all of the legislation that we went through, but also that's affecting family law. So the things that we were able to go through today are the more important, or things that you'll see right away that will affect you. And then in the next episode that we will have, we'll try to go over the rest. Shannon and I will talk about you seeing all of that other stuff, because it is important. So friendly reminder that the PowerPoint slides and your certificate will be available on Monday, January 12th. So those will be sent to you. We've got some upcoming educational events: Ghost in the Machine, the ethics of using AI in legal practice, From Bud to Battle, cannabis issues in family court. That's one I'm helping to organize. And part 1 are financial issues. So that'll be business valuation, income available for support with cannabis issues. So be sure to join us there. And then, of course, as we mentioned, the March 13 to 14 Pismo Beach Miners Council training. And please save on your calendar this year the first one-of-a-kind only Policy and Practice Summit by CLA FLEXCOM in Sacramento. If you are interested in joining FLEXCOM, which would be like something like myself or what Shanon is doing, then the deadline to apply is March 1st. And if you don't even want to apply, you just want to join right away in discussing legislation, you can join a FLEXCOM standing committee. We've got domestic abuse standing committee, technology and innovation, procedure and evidence, support and financial issues, child custody, parenting plans, minors council, juvenile dependency, arts and adoptions, and more. And finally, save the date for the next legislative lens, which will be on February 12th, 2026. Again, same time, same place. Huge thank you to our guest, Greg Gillette, and thank you to Shanon, Quinley, and to all of you for joining us. That's it for today's Legislative Lens. Stay engaged, stay informed, and we'll see you next month.